and welcome to the Montana Human Rights Bureau's presentation on an overview of disability discrimination. In order to understand disability discrimination specifically, you must first understand what discrimination is generally. So what is unlawful discrimination? Unlawful discrimination can be simply defined as an adverse action taken in a protected area against an individual because of his or her protected class status. To help us better understand the definition of discrimination, we're going to break down and define some of its terms. This slide shows a list of the protected areas under discrimination laws that the Bureau enforces. The majority of the cases filed with the Bureau are in the area of employment. Here you see all the protected classes under federal and state laws. Montana's protected classes are the same and overlap with the federal protected classes. But note that Montana law recognizes the additional protected classes of creed, marital and familial status, vaccination status, and political belief, whereas federal law does not. Also note that the protected class of political belief is only applicable in the areas of governmental services and government employment, and familial status only applies to housing discrimination. Complaints alleging disability discrimination have been among the highest filed at the Human Rights Bureau for years. It is a multifaceted, complex area of discrimination laws. Historically speaking, up until recently, the United States approached the issue of disability by separating those who experience disability from the general population. America utilized institutional settings to carry out this segregation, believing it was best for the disabled and the public. As attitudes slowly changed, new laws attempting to address concerns were passed that only partially dealt with the issues surrounding persons with disabilities, such as the Social Security Act in the 1930s and the Rehabilitation Act of 1973. While Social Security was expanded to include people with disabilities, the financial sustainability of the program proved that those benefits were not a long-term solution for most individuals with a disability, and that those who could work needed to find employment. The Rehabilitation Act of 1973 went a long way in addressing training and funding independent living centers to assist those with disabilities. However, employers remained reticent to hire what seemed to be a newly qualified segment of the population. To specifically overcome this obstacle, President George Bush Sr. signed the Americans with Disabilities Act into law in the 1990s. The ADA prohibits discrimination in both public and private employment, public accommodations, and other areas as demonstrated in the 5 titles of the ADA. In the 1970s, Montana enacted the Montana Human Rights Act and the Governmental Code of Fair Practices, which prohibit discrimination against individuals with disabilities. Under Montana law, it is illegal to discriminate against someone with a disability in the areas of employment, public accommodation, housing, education, financing, credit, governmental services, and government employment. Montana discrimination law runs parallel to federal law. The Bureau has a contract with the Equal Employment Opportunity Commission, or EEOC, to investigate complaints of employment discrimination. Therefore, the Bureau applies the ADA, MHRA, and GCFP when determining whether there is reasonable cause to believe discrimination occurred in the area of employment. The Bureau relies heavily on EEOC guidance regarding discrimination laws. So who do these laws apply to? Well, Title I of the ADA only covers employers with 15 or more employees. However, it is important to note that Montana anti-discrimination laws apply to employers even if they only have 1 employee. So what is the definition of disability under anti-discrimination laws? Who is considered to be a member of the protected class of disability? An individual can fall within this protected class if he or she meets the definition of any one of the 3 prongs shown here. The disability discrimination laws apply to an individual who experiences a physical or mental impairment that substantially limits 1 or more major life activities, a person who has a record of such an impairment, or a person who is regarded as or perceived to have such an impairment. This definition is interpreted very broadly due to the Americans with Disabilities Act Amendments Act, which expanded the definition of disability and widened the scope of protection. Congress passed the amendment in 2008 because the courts had defined disability under the ADA in such a restrictive manner that many experiencing impairments such as epilepsy, diabetes, multiple sclerosis, major depression, and bipolar disorder were unable to classify as persons within the protected class of disability. Since that was not the intent of the ADA, Congress amended it to make the focus of claims be on the merits of a case rather than whether the person experiences a disability. A timely example of this is COVID-19. There is no bright-line rule on whether or not a person who contracts COVID-19 is a person with a disability. That question has to be answered on a case-by-case basis using the definition of disability we are going over right now. Depending on the circumstances and how the individual is experiencing COVID-19, he or she may be a person with a physical impairment that substantially limits a major life activity. However, it is also worth reiterating that the definition of disability also includes a person who is perceived to be disabled. That means that if an employer perceives that COVID-19 has made an employee disabled or regards an employee as disabled because of COVID-19, that employee could fall under the definition of the protected class of disability whether or not they actually are disabled by COVID-19. Now we'll take a closer look at each of these three prongs of the definition. The first prong of the definition is a physical or mental impairment that substantially limits one or more major life activities. This prong is what is deemed an actual disability. In order to better understand the definition, we need to define and understand the meaning of the terms within the definition. First up is physical or mental impairment. A physical or mental impairment is a physiological disorder or condition, a cosmetic disfigurement, or an anatomical loss that affects a body system such as neurological, musculoskeletal, special sense organs, respiratory, cardiovascular, skin, endocrine, reproductive, digestive, genitourinary, immune, circulatory, hemic, or lymphatic. We must also understand what a major life activity is to be able to fully evaluate whether or not someone belongs to the protected class of disability. The regulations provide a list of examples that qualify as major life activities. This is a non-exhaustive list. However, the examples provided are generally broad in scope. Major life activities include caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, sitting, reaching, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, interacting with others, working, and the operation of major bodily functions. Although the regulations list working as a major life activity, cases have demonstrated that it should rarely be used on its own in determining whether or not an individual falls within the definition of disability. EEOC guidance suggests that the major life activity of working only applies in very limited situations. The inclusion of the operation of major bodily functions within the major life activities also significantly expands the scope of individuals who will fall under the protected class of disability. Major bodily functions include the immune system, special sense organs and skin, normal cell growth, digestive, genitourinary, bowel, bladder, neurological, brain, respiratory, circulatory, cardiovascular, endocrine, hemic, lymphatic, musculoskeletal, reproductive functions, and the operation of an organ within a body system such as the kidney or liver. Therefore, someone who has been diagnosed with cancer but may not be exhibiting any symptoms yet that would fall under major life activities would still satisfy this part of the definition under major bodily functions since his or her cell growth is abnormal. The 2008 ADA amendments also expanded what it means for an impairment to substantially limit a major life activity. Substantially limit does not mean the same as preventing or severely limiting a major life activity. Rather, it should be construed broadly in favor of including individuals within the definition of disabled. Ultimately, whether an impairment substantially limits a major life activity should be analyzed on an individual basis and in comparison to the majority of people in the general population. In order to understand this concept better, it may be helpful to consider how difficult or painful it is for the person to perform the major life activity, or how much time or effort is required for the person to perform the activity in relation to how most people perform the activity. In relation to the Bureau's investigations of disability discrimination cases, it is important to note that the Bureau is not looking at a charging party's diagnosis alone. Rather, each disability is assessed on a case-by-case basis. People are unique, and so are their conditions and impairments. The Bureau is looking at whether a charging party's impairment substantially limits one or more major life activities. So, for example, if a charging party contends that he is disabled because he has a bad back, the Bureau would want to know how the bad back is impacting his life. Is his ability to perform a particular major life activity substantially limited as compared to most of the general population? Someone who falls under the second prong of the definition of disability is an individual who has a record or history of having been classified as a person with a physical or mental impairment that substantially limits a major life activity. However, they do not currently have a substantially limiting impairment. A past misclassification, such as a person who was mistakenly deemed to have a learning disability, would fall under this prong as well. An individual is regarded as having such an impairment when someone takes an adverse action against the person because of an actual or perceived impairment. It's important to understand that it does not matter whether the action was taken because the person was perceived to have a disability that substantially limited a major life activity, but rather, what matters is whether the action was taken because the individual was believed to have an actual or perceived impairment. If a charging party uses this prong to establish that he or she falls within the protected class of disability, the respondent may have a defense if the impairment was transitory and minor. If the respondent can show that the impairment asserted was minor and lasting 6 months or less, the charging party will not be regarded as having a disability. While the statute defines transitory as a condition lasting less than 6 months, it does not define minor, and courts have addressed this on a case-by-case basis. To assert this defense, the respondent must prove the condition was both objectively transitory and minor. For example, the respondent cannot claim that it believed a charging party's bipolar disorder was transitory and minor when that condition is obviously not minor and lasts more than 6 months. Another example involves a case out of the Third Circuit Court of Appeals where a truck driver took 2 months leave to have a nodule removed from his lung and tested for cancer. The lower court dismissed the case, citing the employee's condition was transitory and minor under the regarded as prong. But the Court of Appeals reversed the court, citing that the condition was indeed transitory since it lasted less than 6 months. However, the lower court failed to analyze whether the condition was actually minor. Remember, the condition must be both transitory and minor to qualify for this defense. Since there's no definition of minor, employers should consult with an attorney before making employment decisions regarding employees who have experienced serious, even if brief, health conditions. However, don't misunderstand the transitory and minor defense. First of all, it only applies to the third prong of the definition. It is only available to a respondent if the charging party is asserting he or she is a member of the protected class of disability because the respondent regarded him or her as having an actual or perceived disability. Second, don't get confused that an impairment that lasts 6 months or less cannot be classified as an actual disability. On the contrary, the ADA regulations specifically state that the effects of an impairment lasting fewer than 6 months can be substantially limiting. So now that you understand what will qualify someone to fall under the protected class of disability, we will next look at the types of disability discrimination cases. Whether or not someone is a person with a disability is a threshold issue, the first element, but not the only element, that must be satisfied when determining if disability discrimination occurred. Disability discrimination can take several different forms, including disparate treatment, harassment, by association, failure to accommodate, and in an indirect way through opposing disability discrimination or requesting an accommodation, which is retaliation. We will now review each type of discrimination as it relates to the protected class of disability. Disparate treatment cases allege that a respondent treated a charging party differently than others based on his or her protected class. The first step of a disability disparate treatment case is the prima facie case. Prima facie is a Latin term that means on its first appearance. The charging party must prove each element of a prima facie case to show that what respondent did, the adverse act, looks like discrimination on its first appearance. The first element requires the charging party prove that he or she falls under the protected class of disability. Next, the charging party must show that he or she was subjected to some type of bad act by respondent. And lastly, the charging party must prove that there is a connection between his or her membership in the protected class and the act taken by respondent. Some evidence that raises a reasonable inference include that the adverse act does not happen to those who are not disabled, or comments that suggest disability was a factor in the act. When analyzing disparate treatment cases, a shifting burden analysis is used. As we just covered, in the first step of analysis, a charging party has the burden of proving the elements of a prima facie case. After the charging party meets that burden, the burden then shifts to the respondent to produce a legitimate, non-discriminatory reason for the adverse act it took against the charging party. Once the respondent produces that legitimate, non-discriminatory reason, the burden then shifts back to the charging party to prove that the reason proffered by respondent is pretext or unworthy of belief. In order to prevail on a disparate treatment complaint, a charging party must prove his or her case by a preponderance of the evidence. This means that discrimination more likely than not occurred. This standard is less onerous than beyond a reasonable doubt or based on clear and convincing evidence. Rather, it is a 51% probability based on the evidence at hand that discrimination occurred. It's important to note that the administrative rules of Montana change this analysis a bit in the event that there's direct evidence of discrimination. When there's direct evidence, there's no shifting burden, but rather the respondent must prove by a preponderance of the evidence that an unlawful motive played no role in the action it took against the charging party. In the alternative, the respondent can prove that the direct evidence is not credible and is unworthy of belief. An example of direct evidence is an email from a school informing a parent that her child is not being accepted for enrollment because his disability would be better served at another school. Another example of direct evidence is a text message from an employer telling an employee he is fired because he has lifting restrictions and other physical limitations. Now we will walk through a case study to show you the shifting burden in action. A charging party filed a disability disparate treatment case with the Bureau against her employer, a restaurant. She alleged she was demoted from management to a server because of her arthritis. Walking through the elements of a prima facie case, charging party experienced arthritis in her hip, which resulted in a visible limp when she walked. Therefore, she experienced a physical impairment that substantially limits the major life activity of walking. Therefore, charging party is a member of the protected class of disability and satisfies the first element. Respondent acknowledges that it demoted charging party. Charging party was subjected to an adverse act and satisfies the second element. When respondent informed charging party of her demotion, charging party asked what she did wrong. Respondent told her, "It's not what you did wrong, it's what you can't do." Other managers had made comments to charging party regarding her limp, such as, "You're killing me and I don't know how you do it." These comments raise a reasonable inference that charging party was demoted because she is a person with a disability and she satisfies the third and final element of the prima facie case. When the burden shifted to respondent, it proffered multiple reasons for demoting charging party, including a poor attitude, poor sales during her leadership, and no knowledge of her disability. Then it was up to charging party to show those reasons were not worthy of belief. Co-workers provided statements disputing that she had a poor attitude at work. Sales records obtained during the Bureau's investigation showed that sales did not suffer under charging party's watch. And respondents' decision makers all acknowledged that they understood that charging party experienced a medical condition that made her walk with a limp. With this evidence, charging party was able to overcome respondents' legitimate non-discriminatory reasons for demoting her. Ultimately, the evidence showed that her limp was more likely than not the reason that she was demoted. An employer may have a defense for adverse actions taken against an employee with a disability if the employer takes those actions because the employee poses a significant risk of substantial harm to the health and safety to his or herself or to others. This is a direct threat defense. However, the employer must first conduct an independent, individualized assessment of the risk of harm posed by the employee prior to taking the adverse employment action. The assessment must take into account all relevant information regarding the employee's work and medical history. Evaluating the employee's medical history must be based on reasonable medical judgment using current medical knowledge tailored specifically to the employee's situation and condition, not just general information about the employee's disability. Also, the employer can only use the direct threat defense if the threat cannot be eliminated or reduced by a reasonable accommodation. For example, if an employee has COPD, which could pose a serious risk to the employee's health if he contracts COVID-19, an employer cannot send the employee home based on a direct threat to his health until the employer first explores possible accommodations to reduce the threat and second, conducts an assessment to determine if the employee's COPD poses a significant risk of substantial harm based on the employee's condition, not just COPD generally. Harassing someone or creating a hostile work environment for someone based on any protected class is unlawful, including disability. The legal framework for a harassment complaint can vary based on what protected area the discrimination occurred in. As you can see here, the elements are different for harassment or a hostile work environment complaint that occurs in the area of employment versus harassment that happens in the area of public accommodation. As it relates to the protected class of disability, generally speaking, a charging party must show that he or she is a person with a disability who is subjected to either offensive or hostile conduct because of their disability. Many times, the conduct comes in the form of comments or unwanted touching. After the charging party establishes that, the remainder of the elements left to prove depends on what protected area the discriminatory acts occurred in. Regarding the last element in the area of employment, how this is applied depends on who was engaged in the harassing behavior. For example, if the harassment is being carried out by a president or owner, the business respondent is always liable. However, if the harassment is carried out by a coworker or non-employee, the business respondent is only liable if it knew or had reason to know about the harassment and did not take prompt corrective action to stop the harassment. It is interesting to note that someone can also file a discrimination complaint for disparate treatment or harassment if they're treated differently because of their association with a person with a disability. This type of complaint is called a by association complaint. An example would be an employer refusing to allow an employee to return to work because the employee's child has diabetes and the employer is fearful of the employee being exposed to COVID-19 at work and making their child who is disabled ill. In this example, the employee is being treated differently or less favorably because of his or her association with a person with a disability. Someone could possibly file a by association complaint if their coworkers repeatedly mocked or teased them because their child talked with a speech impediment, as that would be creating a hostile work environment based on the child's disability. Like harassment, the elements and analysis of accommodations complaints can vary based on the protected area under which discrimination allegedly occurred. The basic elements are that the charging party is a person with a disability who requested an accommodation, and the respondent failed to provide an effective accommodation for the disability. In the area of employment, there are additional considerations, including that both parties engage in the interactive process to determine an effective accommodation in good faith. It is also important to understand that there is no requirement for a respondent to provide the accommodation requested by a charging party, but rather the standard is whether the accommodation provided was effective. If a charging party can establish a failure to accommodate claim, the respondent may be able to put forth a defense of undue hardship. An undue hardship can be in terms of difficulty in implementing the accommodation or the expense associated with implementing the accommodation. Also, a respondent, whether it's an employer or public accommodation, is not required to provide an accommodation that would fundamentally alter its business. After disability, retaliation is the second highest number of filings received by the Bureau each year. It's important to note that retaliation is its own creature, so to speak, rather than a subcategory of disability discrimination. It's a bit indirectly related to disability discrimination. Unlike most other forms of discrimination, the person being retaliated against does not have to be a member of a protected class or associated with a member of a protected class. Here you see the three elements that constitute a prima facie case of retaliation. Retaliation is when a respondent takes a significant adverse act against a person because he or she engaged in protected activity. Protected activities include opposing or objecting to discriminatory acts, participating in an investigation or case of discrimination, and requesting an accommodation. For example, if an employee complains to their boss that they don't like that their coworker is being harassed because of their bipolar disorder, the employee has opposed disability discrimination and engaged in a protected activity. Likewise, if the employee acts as a witness in the employer's investigation into the harassment of the coworker, the employee has engaged in protected activity. And lastly, if the coworker who has bipolar disorder asks for a reasonable accommodation from the employer, the coworker has engaged in protected activity. When determining whether or not the charging party was subjected to an adverse act, the question revolves around whether or not the act may dissuade a reasonable person from engaging in protected activity again. Continuing on with the example just discussed, if the employer gives the employee who reported harassment and participated in the investigation into harassment a poor performance review or demotion because the employee engaged in a protected activity, the employer has retaliated against the employee. It's reasonable to think that a demotion or bad evaluation could dissuade the employee from speaking against discrimination again. Furthermore, if the employer then gives the coworker with bipolar disorder the worst shift available because he asked for an accommodation, the employer retaliated against the coworker because the coworker may think twice about asking for another accommodation based on the less favorable work shift. You should now have a basic understanding of discrimination laws regarding the protected class of disability. Additional, more in-depth trainings on topics covered in this training, such as disability accommodation, harassment, and retaliation, can be found in other training videos offered on the Montana Human Rights Bureau's YouTube page. For more information about discrimination or the Bureau, please visit our website at montanadiscrimination.com or give us a call toll-free at 1-800-542-0807 or locally at 406-444-2884.